And so I wanted to take a moment to kind of get into the real meat of the book and talk about some of the cases that really stuck out to you both.
One of the truly landmark cases, anyone who practices death penalty law, and a lot of people who don't, are familiar with the case of Gregg versus Georgia. The Supreme Court threw out the death penalty in 1972, finding that it was implemented in an arbitrary and capricious manner. That it was like getting struck by lightning. You never know who was going to be executed. Well, states rewrote their death penalty laws. And another case came up in 1976 called Gregg versus Georgia, where they had the opportunity to see what the states had done, what Georgia had done, and perhaps reinstate capital punishment. It was a huge case because opponents of capital punishment thought the earlier decision was just the first shoe, and they could use the Gregg case to rid the country of capital punishment once and for all. And supporters of the death penalty said, well, we can get Humpty Dumpty back on the wall here if the Georgia law is upheld. Troy Gregg was a hitchhiker picked up by a couple of good time Charlies. They stopped to got a case of beer, and then they had to go to the restroom, and they stopped again when they came back. Gregg had a gun, and he shot them both at point blank range to steal their money and steal their car. And the question was, could he get a death sentence? The Supreme Court looked at how Georgia had rewritten its law. It required, one, a bifurcated trial, which means you have one part of the trial to determine if the person's guilty, and a second trial, which is much more open-ended, to determine what's the character of this person and what was so bad about the crime that would justify a death sentence. The court said the Georgia law is fine. Other states scrambled to meet what Georgia had done, to duplicate what Georgia had done, and we all assumed that Gregg then would be the first person to be executed. And in a way he was, but not the way anybody thought. The night before his scheduled execution, he escaped from prison with 4 other inmates, said to be the worst killers in Georgia history. The crimes they had committed were too gruesome, even for our book, which has some gruesome stories in it. They escaped, went up to North Carolina. Some of them, the escapees, were members of a motorcycle gang called the Outlaws. They got together with some old friends. And Gregg had made the unfortunate mistake of slighting the girlfriend of one of the bikers. And a co-escapee picked him up, threw him to the ground, and stomped him to death. His body was found floating in a nearby lake a couple of days later. All the others were apprehended. But Gregg, the escape, which was so daring, got him another 24 hours, and that's about it.
But he died, executed, in a different way than the law had intended. You can't make this stuff up.
Yeah.
No, I mean, but these stories, before the trial, before the crime, and after the crime, after the Supreme Court's decision, we find them fascinating. And if you're a journalist and you're a writer, you want to have good stories to tell. There were others too. I mean, we had one where the issue for the Supreme Court was whether you could forcibly medicate a paranoid schizophrenic inmate to make him well enough to be executed.
The background is, I mean, the court had already decided, okay, if somebody is crazy, you can't put him to death. If somebody becomes insane after conviction, you can't put him to death. But here we have a case of somebody who became, or is at least diagnosed as paranoid schizophrenic after being condemned. The state of Georgia wanted to medicate him so that they could execute him.
Against his will.
Yeah, he wanted no pills, thank you very much. Well, they wanted to medicate him so that he'd become sane enough to execute him. That became a big Supreme Court issue. The court looked at it, accepted the case, because it was an interesting question, and then for some reason punted. It did not decide that question. It sent it down to the lower courts for re-examination. I talked to the trial judge to whom it was sent back, who said, I was scratching my head. I have no idea what these guys want. They reheard the case. Eventually, the Louisiana State Supreme Court made a decision that you couldn't medicate to execute. But the Supreme Court didn't make the decision in that case.
One of the things we uncovered in our work on this case was that this inmate, this murderer, Michael Perry, he was arrested here in Washington, D.C., and actually had come to town here and was stalking Supreme Court Justice Sandra O'Connor. That surprised us, and she still participated in the case. She didn't remember it because, unfortunately, those things do happen with Supreme Court justices as victims of threats. But as Martin was saying, his death sentence was later set aside by the Louisiana Supreme Court. And now what we hear is he has a whole wing to himself in the Georgia State Penitentiary at Angola, because he spends the wee hours of the morning wandering the halls shouting at people only he can see and hear. And that's not as a courtesy to him, but as a courtesy to other inmates.
I started as both misspeaking. This is a Louisiana case, and it's the Louisiana State Penitentiary in Angola. My mistake.
But, it's another one of those cases and another one of those issues that are very, very tough. The Supreme Court says, what do you do with an inmate, whether it's on death row or not, who doesn't want to take his medication? And the court says, well, if you can show that it's medically necessary, you can forcibly medicate them. But what doctor is going to say, yes, it's medically necessary, so you can kill the guy? I mean, another one of the issues I used to lie awake at night thinking about. It so troubled me, not because I cared which was the right way to go, but these are puzzles. In this case, the question was, can you use victim impact statements? You're deciding whether this person who's been convicted, committed the crime, should the jury hear about the impact on loved ones left behind? There were 3 cases. I think they are the 3 most horrible cases in the book. And initially the court said, you can't. Because if you do, somehow, if the relatives are articulate in speaking about what the loss is, the perpetrator might get a death sentence. Where if it happens to be somebody who doesn't have articulate relatives, loved ones left behind, or somebody nobody really knew, well, then the perpetrator might escape a death sentence. That should have no bearing on it. It should be based solely on the crime and the criminal. Well, I would lie awake at night trying to figure out what's the right answer there, because it does seem relevant what the impact is. And the Supreme Court divided 5-4 with Justice Lewis Powell writing the majority opinion saying, no, that's not relevant. Just look at the crime and the criminal. Powell left the court, and the court, another case came up. The court granted it expedited consideration. They flipped that decision, in a heartbeat, in a Washington D.C. Supreme Court heartbeat, which is a couple of years actually. But it was only the change in personnel that did it. And so the court went 5-4 the other way.
But the consequences are fascinating. If you die with no relatives to speak for you, that's a different situation. I mean, is the sentence going to be dependent upon the survival of victims' relatives and their eloquence? Scary stuff.
And I still think that's a tough call. I mean, I don't know what the right answer is on that. Unfortunately, all we have to worry about is presenting the question properly. We don't have to have the answers. And I also, when you look at these cases, you understand the real difference between having an opinion, which we're all entitled to and take no responsibility for usually, and making a decision. John Roberts, when he was nominated to be Chief Justice, addressed that in his confirmation hearings. When you have to make a decision where lives are on the line, you sometimes look at these cases a little differently.
Well, that's an interesting point, because I know that a large part of this book is about you just gathering the information. But I sense definitely that you have an opinion on this, and I think that it is somewhat weaved throughout the book. Do you think that it had any sort of impact on the way that you
Well, I sort of hope it isn't weaved throughout the book, and we tried very hard not to tip our hand.
But what we found was, when we were talking about these brutal crimes and criminals, the book had sort of a pro-death penalty tilt, and that troubled us.
And initially, we did not want to present any conclusions. We wanted it to be sort of hands-off, here are the facts, you decide. The problem, as Tim said, is it started because of all the brutality of these crimes. I mean, the crimes that get to the U.S. Supreme Court are not your 7-Eleven robberies or domestic homicides. These are, for the most part, crimes against innocent people who are in the wrong place at the wrong time, committed by people who are very violent, very screwed up people. And the more we presented the details of those crimes, the more viscerally we felt readers would feel, okay, death penalty is just fine. We take no moral position about the death penalty. You guys decide that. But what we concluded, and we concluded we had to conclude for the sake of our readers and to be honest, we had to present our reservations with the way the system works. Not whether or not you should have the death penalty, but the fact that the system does not seem to work in any equitable way. That for more than 200 years, the brightest, most caring, most dedicated minds in our society, in state legislatures, on the bench, on the Supreme Court, in the legal community, have tried to figure out